This video is gonna go over some stuff. Credit repair business owners do not want you to know because it's how they make their money. The credit bureaus do not want you to know because they make their money by keeping these items on your report. So pay attention to the entire video. Welcome to a new episode of the CAP Podcast Consumer Ammunition Tactics Podcast. So today we're basically just gonna walk y'all through fixing your credit as it pertains to 2024. We're about to hop into 2024, and I need y'all to realize you gotta tighten up your methods as far as credit. I've been in the credit space since 2021, getting consistent results here and there. And the main thing is understanding and being able to pivot. So I understood that as times progress, you got to make that pivot. So we're going to talk about one of the pivots that you have to make today if you haven't made it already. If you're a returning viewer, you probably know about the consumer laws. That's what I'm going to talk about today. And as we step into 2024, credit repair business owner, whether you're doing it yourself, if you want results, you have to understand the consumer laws. Metro 2, all right, cool. It's not going to work like that. You have to understand the consumer laws. The reason why you have to understand the consumer laws is because when it comes to the consumer laws, that's what can actually hold weight when it comes to actually suing these agencies. And this goes back to debt collectors as well, because you can't sue the debt collectors. I'm going to walk y'all through the whole process as far as fixing your credit. Best practices. I got a bunch of videos. I got podcast episodes where you can understand how to fix your credit yourself, but I just want to walk y'all through the process again. Maybe we'll talk about going ahead and get funding as well. So, number one, you want to pull your credit report. But a lot of people mess up here. This is one of the things I was thinking about too. A lot of people mess up because people will just go directly to a place where you could pull all three of your credit reports. But I wouldn't recommend that. What I mean is if you go to Experian and you get the 3 bureau report, the best recommendation I could have for you is, remember, you want the best results. We're going into 2024, so you have to be on your P's and Q's. Some credit repair business owners, they don't want you to know this information. Some of them they're not even cognizant of this. But you want to go to annualcreditreport.com and pull specifically from each one. I'm not saying that it won't be valid if you do a 3 pull as far as Experian and then you get TransUnion, Equifax over there. But it just makes more sense and it's more valuable if you go to specifically each one. So annualcreditreport.com, fill it out for Experian. Annualcreditreport.com, Equifax. Same thing, TransUnion. Pull your report. I got multiple videos going over the process. As I go over the process, it might seem fast. So if you're new to my channel, you're new to my podcast, go to past episodes where I talk about it. So keep that in mind. So fixing your credit in 2024, you have to dissect and understand your credit report, your consumer report, whatever. So you got the report, you got the PDF, literally print it out and mark up the stuff that you want to actually dispute. Names, addresses, phone numbers, right? So you gotta just make sure that everything is on point. Talked about it in previous videos, like I said, but one of the main things I wanted to give y'all value in terms of the video is just putting it in y'all head, y'all subconscious, as far as what a claim can look like. So you pull your reports. I want to give y'all an example of a maximum possible accuracy claim. So this is something you can literally sue the credit bureaus for. And it's different from the investigation section, 15 USC 1681I, because with the maximum possible accuracy section, this is compliance procedures. It's different from the investigation section because the investigation section, in order for it to actually be the claim, you have to follow the procedure of notifying them. With what I'm gonna tell you, the 1681E claim, EB claim, you don't have to notify them. It's compliance procedures. It means that they already have to have systems in place to make sure these inaccuracies don't occur. So let me give you a very simple claim that you may or may not be able to relate to. And remember, there's multiple different claims you can make, but I just want to give you all this just so you can have it in your head. And if you have a credit repair business, this is something you should be looking out for your clients. Look out for it for yourself if you're doing your credit yourself. The credit bureaus do not want you to get this information. So if you like the information I'm putting out, give me a like, give me a subscribe, give me a share, whatever your spirit tells you to do. You feel me? All right, so 15 USC 1681E, 1681EB, it basically says it's a maximum possible accuracy law. If you followed me, you probably see me talk about it. Basically, it says anything. It's pretty much essentially if they're supposed to have a reasonable cause. If they have reasonable cause to believe the information is inaccurate, they're supposed to remove it. Like everything is supposed to be maximum possible accuracy, right? So maximum possible accuracy, right? So no, the map if the reasonable cause to believe the information is inaccurate, I think I'm talking about 1681 S-2. The 1681 EB is a maximum possible accuracy law. It has to be maximum possible accuracy. What does that mean? It's not minimum possible accuracy. Everything has to be completely accurate. So the claim that I want to give y'all, is basically, what's it called? It's essentially, how can I give y'all an example? So let's say you're born in 1999. And then on your credit report, it says you have an account that was open in 1998. That would be a maximum possible accuracy violation because that's not possible. Let me even pull up the law just so I can give y'all the exact, verbiage of the law. The 15 USC 1681E. EB is the maximum possible accuracy law. 1681E. Compliance procedures, like I said. Hold on. All these damn pop-ups. Okay, yeah. When I was saying, I think I said reasonable cause to believe the information is inaccurate. That's 1681 S-2, but it's reasonable procedures. That's what it is. Okay, cool. So whenever a consumer reporting agency, that is TransUnion, Experian, Equifax, prepares a consumer report, what is that? That's your credit report. It shall, if you look up the term, it has to be done. It shall follow reasonable procedures to assure maximum possible accuracy, right? So whenever you hear 1681 EB, just think maximum possible accuracy. That's how I, know it. I've been reading these consumer laws since 2021. So if I'm quoting them and you're just like, okay, this section, if it seems like, it's hard to catch up, just remember that, I've been doing this since 2021. Information concerning an individual about whom the report relates. So basically maximum possible accuracy. So I just gave y'all a potential claim that can happen. If you were born in 1999, it says you have an account that was open in 1998. That literally doesn't make sense because you weren't even here. So you don't even have to notify them. That's already a violation because they violated the maximum possible accuracy, their compliance procedures. They're supposed to have systems in place already that prevents stuff like that from happening. So this is what I need y'all to understand when it comes to the compliance procedure section. There's multiple stuff within the FCRA as far as where you can actually get your claim, but I just want y'all to be in the mindset of knowing where your actual claim is. Because in order for you to have a claim where relief could be granted, you might see that in the legal language if you're filing a lawsuit. That's basically what they're talking about. You have to have a claim and you have to state your claim. Rule 12B, number 6. If you Google that, you look it up, that's basically where they say you have a claim where relief cannot be granted. So if you file a lawsuit, I bet you the attorney or whoever's representing them is going to hit you with that. Even if you do have a claim, that's typically what they tend to do. None of what I'm saying is legal advice, by the way. So keep that in mind. On the flip side, if you're being sued, let's say debt collector or whatever, you could use a Rule 12B number 6 as a defense motion, right? So just keep that in mind. Keep in mind what I'm saying. Maybe replay the video, replay the podcast, and apply it to your situation. So the best practices I want y'all to understand. Go ahead and make sure that when you pull that report, it's not just from a Experian.com and then TransUnion Equifax is also attached. Specifically go to each individual site. That's why I recommend as best practices, because you want to prepare as if you're going to court with these people. These people are crooks. They're going to keep violating you if you don't, do what you can to go ahead and make things right. So keep that in mind. So no matter what negative item you have, you need to be able to articulate yourself as far as the consumer laws to get those items deleted. Now, let me give y'all like a holistic answer for being able to get these negative items deleted. Number one, you need to have the mindset that you're going to go about it in terms of just understanding that you need to customize your letter, customize your situation, because every situation is different. I got a mentorship program. My students may ask me, how do you remove XYZ? I might tell them, if two of them do the same thing, one person may get the deletion, the other person may not, for whatever reason. It's just how the credit game works. So you got to understand that this is a game that is unpredictable. So in order to survive in 2024, as far as your credit, you got to understand these laws and create your own customized process. So the overall, like I said, the like holistic answer, you go to the congressional findings section in the FCRA, the Fair Credit Reporting Act. It says the banking system is dependent upon fair and accurate credit reporting. The banking system is dependent upon fair and accurate credit reporting. What does that mean? It means that these banks need us. Banks are borrowers. You go to the Title 12 laws. I'm not going to get into that, but if you see me talk about it before, you know what I'm referencing. So because the banks are borrowers, because they need us, you need to understand that your credit is very important. Your credit is very powerful. It's about leverage. Don't just have a cute credit score. What are you doing with it? How are you using that credit? Are you using it to get funding? Are you using it to get a house? Are you using it to make an investment? Are you using it to get a vehicle, your dream car? It holds a lot of power. Are you using it to be irresponsible? That's something you need to ask yourself as well. Credit holds a lot of power. With great power comes great responsibility. There's a lot of power in the knowledge of these consumer laws. Those of y'all that know about the laws that have been following me, so you know that there's power in the information. It's just how you use the information. So going back to what I said, the holistic answer. Number one, I want to give you two laws. 15 USC 1681B, the permissible purpose section. If you've heard about consumer laws, you're probably familiar with that section. That section is powerful. 1681B number 2 talks about, the fact that things aren't supposed to be put on your report without your written consent. So just understanding and articulating that. Don't just copy and paste the law. Remember, we're talking about best practices. We're going into 2024. You have to be able to articulate yourself differently from most people if you want to get that deletion. So 15 USC 1681B number 2, it's not supposed to be on your report without your written instructions. Combine that, this is what my recommendation. Combine that with 15 USC 1681C-2, C as in cat, right? Like my company, cat. All right, so the block of information resulting from identity theft section. So identity theft is not the traditional way of identity theft. It's more so, when we talk about identity theft, we're more so talking about without consent. So if you go to the Federal Trade Commission website, the FTC website, they're gonna walk y'all through the fact that identity theft is without your written consent, your written permission. Why is that important? That relates back to what we just initially said, permissible purpose. That's why we marry the two laws. Permissible purpose, the lack of your permissible purpose, meaning the credit bureaus, leads to that block of information resulting from identity theft. So it shall be deleted within 4 business days of them receiving your identity theft report, as well as the 4 requirements that the law speaks about. So this is why I want you to understand and articulate. So then it transitions into 1681N. 1681N, what is that? That's civil liability for willful non-compliance. So now they're willfully not compliant because you pointed out the law to them, and now they have reasonable cause to believe that the information is inaccurate. Now we go to the 1681S-2 that I was referencing earlier. Then we also have negligence, 1681O. So that's just an additional extra credit. So what I recommend that you do as far as, disputing 2024, whatever you have, if you got to correct your name or whatever, you got a, collection, you most definitely should be sending a debt validation to the actual creditor, the company. But you can also just articulate what I just said in a notice. You fill out your FTC identity theft report. I recommend that you also do a CFPB complaint, Consumer Financial Protection Bureau, right? You put that on over there as well. That's just extra measure to go ahead and get the thing deleted. Sometimes some people are like, oh, do you need to freeze the bureaus? I'm gonna be transparent. When I first started in 2021, I did all that, but it was a certain time when I literally just first started my journey in 2021. I didn't know about consumer laws. I learned about consumer laws that same year in 2021. So then I tested it out. I stopped freezing the secondary bureaus. All those LexisNexis people, I stopped freezing them. Still getting results. But one thing I will say, if you are dealing with a bankruptcy, it does not hurt to still freeze them, and obviously dispute with LexisNexis, and LCI works with TransUnion. So just going about the process that way. So it's not a requirement because we're speaking about law. It's a law here. And I'm going to tell you, this is where the mindset is very, very important, is you're going to send letters out sometimes, and they're going to go ahead and say verified, or they're going to send you, templates of BS, even though you've articulated the law. They will do all that, but at the end of the day, you have to remember, we live in a society, corporation, United States, 28 USC 3002, right? You got to understand that this corporation is ran by what? Money. Everything is about money. Everything is about money. So you got to understand, if everything is about money, how can you actually get these people? You have to structure your paperwork to where you're going to have to take them to court, where you're going to have to sue them. You can sue them in small claims. You can sue them in district courts. You can go through arbitration. It's really up to you how you go about the process. And that's not legal advice. But I say that to say, if you're sending letter after letter, it's not going to work necessarily. It's not going to work in every case, right? You still want to go a number of rounds, but it's not going to work in every case. This is why in 2024, the game is changing. You could be using these AI software. You could be doing Metro 2. You could be doing all that. But at the end of the day, the people that's going to last forever and get results are people that understand the consumer laws and using that with like factual disputing. Factual disputing, looking at the credit report line by line. Okay, different open days, different closing days. Violation of 1681 EB. Okay, they didn't have permissible purpose. Block of information resulting from identity theft. Okay, the investigation section of 1681I, A1A. You can go look that up too. That's powerful. So I need y'all to understand that. So you sent out your letter, right? You've drafted everything. You've pointed out everything you want to get deleted. You've done your FTC identity theft report. You did all that, right? So then you send it out. And everything I'm giving y'all right now, y'all can literally start your credit repair business based off of this information. And the dope thing about the information I put out, and just information in general, and the type of time that we're in right now, everything I'm packaging in this episode is gems upon gems upon gems. It's so many pieces of content that you could create yourself, right? We're heading into 2024. If you're not creating content and you consider yourself someone that's in credit repair, then you a dummy. You have to create content. You have to create content. You have to create content. I don't care what business you're in. 2024, you have to create content. I know what's going on. That's why I invest a lot of money into my content team. My marketing team in CAT paid them a lot of money to be producing this content for me. So I need y'all to realize, content. Don't y'all figure out, like, isn't it weird that someone like a Gary Vee is consistently putting out a lot of content and has big team investing lots of money? This content is important. Okay? So this is not just about understanding how to fix your credit, but it's just understanding how business works. Content. This video alone that I'm producing right now, that I'm recording, my team is gonna chop it into a bunch of different snippets. It's gonna bring back money. You know, this video is gonna be on YouTube. There's gonna get watch time. There's gonna be ads. Do not skip my ads. You know, that's money, right? So money's gonna come in that way as well. So I need y'all to realize, not only fixing your credit, but just understanding how business works. If you want to take it as a business, you can create an ebook off of everything I'm saying, that stuff like that. So use those laws. You sent out your first letter, right? All right, cool. You did your CFPB complaint. Make your CFPB account if you did not. And then let's say they say, okay, verify, right? The typical verify. I put out a whole YouTube video already for that method of verification, right? So go ahead and watch that video. But just to brush up on the topic, if they hit you with verified, you want to follow up with how. Don't just accept verified. They're supposed to tell you verified. You should go into it expecting to be told verified. You're going to get some items deleted, I'm pretty sure, within that first round. But you should go into it expecting to be told verified. That's a mindset I want y'all to have. So go into it like, okay, I know they're going to say verified, so I'm going to prepare my next letter. So then we're going to focus on method of verification. Asking them, how did they verify? If they love saying verified, you got to understand there's millions of consumers submitting complaints. They're not verifying nothing. It's a computer system. If you don't know about eOscar, go ahead and look it up. I spoke about it in previous podcast episodes, I'm pretty sure. Probably on the YouTube as well. But the eOscar system is most likely giving you that code. So you need to understand. Now we get into the technicalities. I'm not going to get into it, but the technicalities of, you could physically write your notices, right? You could highlight it different colors. You could staple it, stuff like that, right? So now we're getting into those technicalities, but the main thing I want y'all to take from it, going into 2024, you need to be able to press them. What was the method of verification? 15 USC 1681I number 7, method of verification. Look at that law, break it down and really understand it. And then walk through creating your own customized method of verification notice. So now what do? Send it out. I didn't say all this, but y'all should know. Send everything certified mail, green return receipt. You want to keep everything because that's going to be your exhibit, your evidence if it goes to court. I don't know if y'all remember that video I dropped when I was talking about how I sued, I helped my client sue TransUnion. We had those exhibits. That's why they folded. Like, okay, we're going to delete these items. You got to press them where it hurts. Where does it hurt? Money. Everything is about money. I need y'all to understand that. Everything is about money. So now you sent out a method of verification notice. Okay, cool. You did a certified mail. You referenced, I sent you an initial notice that you talked about some verified. So how did you verify it, right? So now we're going into a third notice. So your third notice is really up to you. So typically our third notice is a pre-litigation notice / reiterating our previous points. So what do I mean by that? We're letting them know this is the final note. This is a pre-litigation notice. We plan to sue if you don't make this right. So we're going to reference, we sent you letter number 1 and we're referring again, right? Typically by the time we're at letter number 3, if we had 10, 15 items we were disputing, we're probably down to like less than 7. They still are to be deleted. So we'll reference like, okay, we sent you letter 1, you deleted it. If you deleted those, why are you not deleting this item? We sent you a method of verification. You didn't provide us with how you did the method of verification. So when you do the method of verification, they may send you something, but you got to just break it down and see if that actually classifies as adequate method of verification. So really dissect the FCRA. That's really like y'all sauce, dissecting the FCRA. So you know what constitutes an actual method of verification. And when we break it down, their method of verification is low-key irrelevant based off of, the claim that we're doing, based off of the permissible purpose and block of information resulting from identity theft. Because you got to understand what's actually going in that claim. They didn't have permission. So by definition, that's identity theft. I brought that to your attention, so you need to remove it. You can also tie in that method of verification 1681S-2 because they have reasonable cause to believe the information is inaccurate. I also encourage you to tie in the congressional findings section. It talks about basically the whole procedure of how the congressional findings of the FCRA, why it was founded. Remember, the banking system is dependent upon fair and accurate credit reporting. So remember that they assumed this role. They took it upon themselves. So keep that in mind. Just the whole main thing I want y'all to get is that everything is customized. Yeah, I'm giving you templates step by step, but you want to customize your situation. Yeah, we sent letter number 1. We're talking about permissible purpose, block of information. We could be talking about compliance procedures if we want to go with that claim I initially talked about, right? But then also, you sent that letter out, but then now we're going to go to the investigation section, 1681I number 7, right? Because we're doing the method of verification. Okay, they still on BS, right? Where they sent us like a BS verification. Now we're going to talk about pre-litigation notice. So once you send a pre-litigation notice, it's really up to you. For what we do, typically with our business, we're working at volume as far as our clients. So at that point, after the pre-litigation notice, it's really dependent upon the client because I'm not filing for myself. It's based on the client. So it's up to them if they're comfortable enough to go through the litigation process. Some may be like, I'm not comfortable with that. I want to send more letters. If it's you fixing your credit for yourself, to me, you already have enough for a claim. And I have proof as far as, what I've experienced helping people. By the time you send that pre-litigation notice, you've let them know. Once you actually, this is going to get into the actual legal advice. And this is not legal advice. But once you actually are filing your lawsuit, your statement of claim, I recommend your statement of claim form is just reiterating the whole process of what you've done. This is why dates are important. Dates. This is why the delivery of that mail is important. Because you're going to have to explain all that. They're going to ask you, did you attempt to already get money from this person? This is where, I didn't talk about it, but this is where the whole invoicing thing comes in. This is why you want to be able to mark up the violations. on your actual consumer report, your credit report. So just take everything I'm saying and then like paint it to your own situation. So letter number 4, if you send a pre-litigation notice, you can already file that, not legal advice, but you can file a lawsuit, right? You can file a lawsuit after you put them on notice, number 1, to be honest. But remember, if you're going for a 1681E claim, remember the example I gave y'all. You don't technically have to notify them. You're just pointing out what happened. So you send letter number 3. For the sake of conversation, let's send letter number 4. We're reiterating everything we've done in the previous notices, and you want to document everything. You want to also document the CFPB complaints that you're printing out. Sometimes the weird thing about credit, sometimes the weird thing is, like for hard inquiries, for example, let me speak about that. So you might send in, like mail it out to TransUnion or Equifax if you're faxing or mailing. You might call them and they're gonna say, oh, we didn't receive it. You do the same exact step the next time around, and then it just gets deleted. That's why credit is so unpredictable, and I want y'all to look at it as like a boxing match, because you're like one letter away from getting that deletion. So letter number 4, to reiterate your point. Letter number 5, you could reiterate your point. You could do it as much as you want until you actually want to sue them. And what I recommend, if you've never done it before, if you're like antsy about it, like, oh, I don't know how it would go, if you send at least 4 notices, I think you're good enough to go, to be honest. So I would highly recommend, because I'm not giving you legal advice, I would highly recommend that you get get a free consultation from a consumer lawyer. So you can go to consumeradvocates.org. That's a resource I give to my students. You can go ahead and go over there, just explain everything you've done. This is why documentation is important. They may be able to take on your case. They'll help you get that item deleted. When it comes to FDCPA, Fair Debt Collection Practices Act, collections, that's a whole different ballgame. These people calling you, texting you, violating you in that manner. That's where you can go ahead and resolve those situations. And same thing if you want to communicate with the attorney, they'll be able to help you. I'm not going to talk about the funding aspect in this video or this podcast episode, because I feel like it's getting pretty lengthy. So what we're going to do a part 2. So the way we're going to do the part 2, I'm going to see y'all next week, and we're going to talk about a 3-step process to help you get 100K in business funding. With that being said, hopefully y'all take action from what I said today. Fix your personal credit, make sure it's on point, so that by the time we get to part 2, you're going to be able to get to the next level. So with that being said, y'all have a blessed one.